Welcome, everybody. Happy Wednesday, and welcome to Webinar Wednesday with Bill Bronchick, your host, moi. Today, we're going to be talking about a very important topic for you as real estate investors, and I'd like you to participate by popping in your questions and comments as we go, and I'll answer questions, periodically through as I see fit, and probably answer most of the questions at the end. So today, we're going to be talking about common real estate investing scams, 7 most common real estate investing scams. I've been involved in real estate investing for over 30 years as a real estate attorney for over 30 years. Coming up in January 2022, that'll be 31 years as a real estate attorney. And I used to run the Colorado Association of Real Estate Investors for many years, met thousands of investors there in and out, done closings through my high title and escrow, my escrow company, and I can't tell you how many webinars, seminars, workshops, events I've spoken at, other real estate groups. So I've met tens of thousands of investors, and I've seen just about every scam possible that could be pulled on a real estate investor. Particularly, what we see is them pulling it on more unsophisticated investors, but not just unsophisticated investors. A lot of times, people with experience get duped as well. So don't think this only applies to beginners. It applies to all real estate investors. And as we go in it, you'll start to recognize some of these patterns that you may have seen in the past and hopefully have walked away from. Hopefully not. You're going to tell me that you had participated in the investment and got scammed similarly. I hope that is not the answer. So here we go. Let's get into them one by one. So number one, in real estate investing, there's what you know, what you don't know, and what you don't know that you don't know. And that's the really scary part, because that's usually too late at that point. You discover when everything blows up what you don't know that you don't know. So pay careful attention. Scam number one, wholesale deals. Excuse me while I sip on my cappuccino. It's not a product placement, by the way. I just happen to like the Nespresso machine. Are all wholesale deals scams? No, that's not what I'm saying here. What I'm suggesting to you is there are certain deals in wholesaling that can become scammy. So the most common things are a misrepresented ARV or after repaired values and no comps provided. So a more sophisticated investor or more experienced investor, or maybe even a beginning investor, presents a wholesale deal to another investor who's usually unsophisticated and or a newbie, and suggests that the property after it's repaired is worth a certain dollar amount, and they know it's not even close, or they're just puffing, and they call that in the sales business. I mean, they're exaggerating to some extent the value of the property once it's fixed up. Number two, they often misrepresent the repairs. Usually because there's no list of repairs. They'll say it needs $40,000, but no broken down list, room by room, item by item. They're just taking a guess, usually what they relied on what someone else said as the required repairs to get it to after repaired value. So in order to do the calculation, you need to know, what is it worth now? How much work in dollar amount you have to put in it to get it to the stated after repaired value? And does this make sense for you as an investment? Because I've seen a lot of people say, well, it's worth 100. I'm using round numbers. I know 100 doesn't exist in most markets, but just for the math, follow me. It's worth 100 fixed up. You could buy it for 70 now, and it needs 20 in repairs, so you'll make 10. Now, that may sound appealing, but any investor who's been through the system a few times, been through deals, been around the block, knows that $10,000 is not profit. It's a $10,000 loss, what I just described. Because it's not just what you buy it for plus what you put into it minus what you sell it for. There's all kinds of other costs involved. There's soft costs like realtor fees, closing costs, financing fees, carrying costs, property taxes, et cetera, et cetera, et cetera, et cetera. So you need to know all of those things before you go in your own formula, before you look at their represented ARV and repairs. The next thing is non-refundable earnest money, very typical in wholesale deals because they move very quickly and they want to make sure that you're not going to, back out on the deal before their time is up to close the deal. Now, is non-refundable earnest money always a red flag? No, but it depends on how much non-refundable money and when it goes non-refundable. So there may be a time period of 48 hours or 24 or even 12 hours to give you an opportunity to inspect the property, and then the money goes hard or firm or non-refundable. If you do that, just understand that you lose that money. Non-refundable, or ask upfront, is this refundable? Is it non-refundable? Because a lot of people don't ask. They just assume it's refundable if they don't close on the deal, and it's not always refundable. So make sure it is. And if for example, the investor in question is wholesaling the property for a $10,000 profit, should you be required to put up $10,000 in earnest money? Not necessarily. You may negotiate that. So we'll talk about that in a minute. Won't show you the contract. This is a red flag right away. So they represent that they have a deal under contract with the titled homeowner, and that they are going to assign that contract, for example, to you or double close with you. Let's see the contract. Let's see proof that you actually control this property. If they won't show you the agreement, it means one of two things. A, they're lying. B, they don't want you to go around their back and maybe go steal the deal, which is a reasonable concern. But more likely, the third one is they may be re-wholesaling it, which we'll talk about in a moment. They want you to pay money up front before even viewing the property. That's non-refundable? Absolutely not. This is a dead red flag. No reasonable investor asks for cash up front, non-refundable, before you can see the property, or before you can see the contract, before you can see all these other things. And that is, a red flag right there. And he doesn't disclose, or she doesn't disclose, it's a reflip, reassign, or a stacked wholesale. What that means is person A is entitled, agreed to sell it to person B, who agreed to sell it to person C, yet another investor, who's now trying to flip it to you, person D. It means it's being re-wholesaled a few times. Or it's joint venture wholesale, where person B has it under contract with person A, and person C is marketing it to you as his wholesale when it's in fact B's wholesale, and he's getting a piece of it. So just make sure everything adds up here, and that you're not in a complete multi-level marketing scheme, so to speak, and that you really have a deal here going on that you can close on, that you don't get, hopefully not scammed on. All right. You'll see I put a ticker on the bottom there. It's for my website, legalwiz.com/store, which has all my products there. And we got a code discount for 50% off using the code WIZ, W-I-Z, like Legal Wiz. That's good for this week only. So make sure if you're watching this as a replay, and this will be available as a replay, that you act on this quickly. Yeah, someone wrote here, daisy chain, Matt. That's right. It's a daisy chain. It is the stacked wholesale deal. Okay. Next. So how to avoid scams like this? How do I avoid scam number one? Number one, do your own due diligence. Do your own comps. Relying on the person selling you an investment to tell you what the investment is worth is like asking a barber, how's the haircut? Right? You've got to do your own comps. Don't rely on the broker or the wholesaler or anyone else selling you the deal to tell you what the value of the property is worth. Do your own comps. And by the way, ask for comps. If the seller has comps and they don't match yours, ask for his or her comps. Ask for a detail of repairs. If they say it needs 40,000 repairs, ask them, what does that add up to, room by room, item by item? Maybe not detailed cost of a doorknob. You don't have to go that bad, but at least it should say new cabinets, new countertops, new garage door, new roof, and it breaks down to maybe not item by item in numbers, like what each one costs, but at least a detailed list that they got the 40,000 for, and then kind of, based on your experience, or maybe get a second opinion of some other investor or contractor, do these numbers add up? Third, negotiate earnest money and who holds it. This is important. A lot of wholesalers will ask other investors who want to lock up the deal for earnest money. And that investor is going to hold the earnest money. That's not the smartest thing, especially if it's going to be refundable in part. You should have a third party, like a title company or an attorney or a broker or someone else, hold escrow of the money. Otherwise, possession is 9/10 of the law. You've heard that expression. If the seller has your money, you have to sue him to get it back, and that puts you behind the 8 ball. If things go wrong, I would rather see a third party hold it so they don't have access to it. You don't have access to it. Sort of like détente. You have to resolve it by either mediation or a lawsuit or a judge or something like that. So negotiate the earnest money. If they say, well, my fee is $10,000 and I want all $10,000 up front, negotiate this. Ask for 3 up front or 5 up front or something like that. Or maybe you give the 10, but 5 is firm and 5 is refundable, whatever it may be. Ask for a copy of the contract with the owner. Again, I talked about this earlier. It is not unreasonable for you to ask for the copy of the contract. And now, if the owner is the title owner of record, the investor can't hide that because you could look it up. But it should match what's on the contract. So he's not really protecting the deal from you stealing it by whiting out the owner's name when the owner's name is of record. You just want to see if that matches. So if it doesn't match, something's wrong. Ask for a short inspection period. Now, most wholesalers say, give me $5,000, non-refundable, and I'll sell the deal to you, and you have 10 days to close it. That's not unreasonable if they only have 10 days to close it or 15 days to close it. If they have a little more time than 10 days, then ask them to maybe give you a short inspection period, 24 or 48 hours to get in there, look at the property, inspect it with your partner, contractor, mentor, whoever, just to get your second set of eyeballs on it. And then after that, if you back out, you get your money back or part of it back or most of it back. So you're not losing your earnest money if you back out. Ask if this is a reassignment. Ask if this is a reassignment of contract. Or is it the direct one, meaning he's in contract directly with the owner? Scam number 2, joint venture opportunities. Now, not all joint venture opportunities are scams in real estate, but these are the things to look out for. You're not a partner in the entity holding title, which would be, let's say, an LLC holding title to the property. So you're not a member of that LLC or become a member when you're a partner. Or you're not at least a secured lien holder with a mortgage or deed of trust against the property. So you have nothing to collateralize your money with, so you have very little recourse in case things go wrong. So that's a red flag. You have no JV agreement at all with the JV partner who's offering it. That is a big, big, big red flag. If they don't have, if you say, well, send me over your joint venture agreement, they go, we don't have one. We just do this, friendly handshake. Gentlemen, we don't want to get lawyers involved. That's a red flag. That is a red flag. Or they just have a really weak one. That's like 1 page, 3 paragraphs. That's a red flag. You're not involved in any way with the decision making in the deal. If you're going to do a joint venture and you're not secured, you're not a lien holder, you're not a partner in his entity, or maybe in an entity that holds title like a trust, and you have no decision making or veto power, how do you get paid and make sure you get paid back? So if it's a syndication, it may be different. We'll talk about that in a little bit. But a syndication implies that you won't be involved in decision making, but still you have to have some way to make sure that your money is collateralized. If you get paid after closing, you should get paid at closing as a JV partner. Now, if you have a joint venture agreement, you could have it such that you get paid out as a secured lien holder at closing or as a joint venture partner closing. But if you're not going to be paid in closing, and that alone is not a red flag, but in combination with some of these other things, just be careful of that. So how to avoid this number 2 scam on the JVs? First, be a partner in the title holding entity or use a land trust to hold title so that your LLC and his LLC, for example, are the co-beneficiaries, and you're maybe a trustee or you have some voting power, or be a secured lender against the property. So instead of being a JV partner, just lend him the money, get a mortgage or deed of trust against the property, and now you get paid at closing. You're guaranteed to get paid at closing because you're a lien holder. They can't close without you. Check title now. Who is on title? Ask for a copy of the contract between this investor who's offering the joint venture partnership and the title's owner if it hasn't closed yet. If it's already closed, then his entity should be on title. If it's a land trust, ask for a copy of the land trust agreement. It shows his connection to that title holding entity. Get paid at closing. At closing. That's your best way to avoid being scammed. And have maybe some sort of veto power in this joint venture agreement that gives you the right to veto maybe the purchase price that you resell it for, or the amount of repairs that are going to be done, or some sort of decision that makes you have some sort of power in this arrangement, so that you have the ability to have some sort of control of your money. Okay. Number 3 scam, unsecured lender. So an investor offers you a note only, no mortgage or lien against the property. That is a little sketchy. Now, in a syndication scenario, it may not be, or may be, depending on how many other investors are involved. But if someone just offers you a note with no collateral against the property, that is a red flag, because again, you have no way to get paid at closing unless there's some sort of agreement that says so. You're lending to an entity other than who's on title. You check title. Title says entity 1 owns the property. The note that they're offering you says entity B is the borrower. Well, which one is it? Unless if you're getting a lien against the property, they have to match. So that's a red flag. There are multiple other lenders in front of you, either secured or unsecured, and you should be asking this, by the way, if there's other lenders. And there's no legal recourse on default, meaning if they don't pay you at closing, well, then what happens? If they don't pay you after closing, like they said they would, and you were foolish enough to allow that, what happens if 10 days goes by, a month goes by, 6 months goes by? Is there any legal recourse for you against the property, the person, the entity, and so forth? So these are all kind of red flags when someone offering you a deal where you're an unsecured lender. How to avoid these scams? Number 1, be a secured lender. B, get a collateral against the property, such as a mortgage, deed of trust, or something like that. Number 2, check title. Who is on title? Make sure it matches who you're lending to. Ask for a title commitment if you don't have the ability to check title. And that will tell you also not only who is on title, but other lenders that might be secured. So if they're saying, I'm borrowing 50 grand from you, and the title commitment says the proposed insured for lending is person or entity A and B, that means there's 2 secured liens against the property, and you're in 3rd position with an unsecured lien. Not good. And have a provision that allows you to have recourse against the borrower, not just the property. Sometimes notes and mortgages and things will say that in the event of default, the lender's only recourse, which is you, is to go after the property. But if there's multiple liens, that's useless. You want to go after the borrower, and maybe even if it's an entity, ask for a personal guarantee of the individual, particularly in an unsecured note situation. If they won't give you a personal guarantee, that's a red flag. Not by itself, again, but in combination with other things. So if you're dealing with a $500,000 property and you're lending 50% loan to value, 250, no one should have a problem giving you a personal guarantee, because they're really not at risk of losing money personally. But if they say, no, I don't want a personal guarantee, and you discover from that request that there are multiple other lenders, that should be a red flag. So scam number 4, mini syndication, a mini syndication. Now, just let me back up and tell you what a regular syndication is. A syndication is a situation where an investor forms, let's say, an LLC, is going to purchase a commercial project of multi-millions, is going to ask multiple investors to invest in that entity as either partners in that LLC, becoming actual owners of the LLC, or become lenders with liens against the property. Either one can be a syndication. If we're dealing with 3 or 4 people lending, or 2 or 3, they may not see the need for this. They may think in their mind that syndication only applies to 10 or more partners, which is not true. It could be as little as 1 partner, and they think that's not important. So many syndicators, when an investor fails to understand or comply with any securities regs, and when you ask them, they have no clue what they're doing, they don't even know it, they don't know about it, that should be a red flag. Or the investor knows, but takes it, don't worry about it, it's a small project, don't worry about it. that is a red flag, because that means what else in what they're doing with your money or the project are they going to take that attitude with? Oh, we don't need permits. That's not a problem with the property. We don't need to comply with code regulations about the HVAC or the plumbing or the electrical wiring. You know, it extends to other things. If the investor's in a rush, hurry, 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 got to close by tomorrow, I need the money, and won't give you time to do due diligence, that should be like 80% of the red flag right there. An investor fails to disclose relevant risks. Now, what is relevant? You may not know, but if they have any history as a real estate investor, good or bad, if they've been sued, if they've been filed bankruptcy, if they've if they've been arrested or charged with crimes, all those things are relevant disclosures. And you may not know about these things, but if there's no disclosures of any kind, that should be a red flag right there. Or the investor takes requests or questions personally. You ever had this situation where you say, well, I have to ask you, Mr. Investor, blah, blah, blah. And they said, oh, you're just grilling me, blah, 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 blah. Oh, you're just trying to corner me. You're acting like a prosecutor. This is a friendly transaction. That should be a red flag, a big fat one. And I've dealt with people like that who acted like they were the biggest big shot in the world. And when you said, ask for a simple thing like, do you have a copy of the contract with the owner? And they went, oh, what are you asking for? You don't trust me? I'm a reputable person. I don't need this crap. That's a red flag. Obviously, they do need this crap because they're asking you for the money. So if they start getting angry with you or defensive, that should be a red flag. That should be a red flag. Okay. So to avoid these, ask, is this a formal syndication? If they don't know what that means, then you should be weary. Ask them if it is for a private placement memorandum or offering documents, a PPM or offering docs. Again, if they don't know what that means, that's trouble. Now, if they know what it means, but they say, well, this is kind of a small project, just you, me, and my brother. All right, maybe, but let's look at the other factors. Ask them for the copy of their LLC docs. If they're asking you to become a partner in their LLC as the investment, ask for a copy of the operating agreement, the articles, the tax ID number, all the stuff. Ask for a disclosure of risks if they haven't given one. If they don't know what that means, or if they get defensive, that should be a red flag. Ask for a lien against the property. Oh, look, I'd like to lend you money, but it's unsecured. You're giving me an interest in an LLC. I'm not the manager. I don't have majority voting rights. Would you mind giving me a mortgage or deed of trust against the property? If they get defensive or say, I already have 3 other lien holders, that should be a problem. And also ask lots of questions generally and just watch their reaction. Just watch for the reaction. Zoom them instead of email them and see how they react to your questions. If they get defensive, if they get nervous, if they get angry with you, all those should be big, fat, red flags. All right, let's take some questions now at this point. Let's see. We've got... Thank you. Someone just said they saw me at Cody's free house formula event in Phoenix and crushed it. Thank you very much, Janine. That was a good time. Cody is a great guy. I really enjoyed that event. All right. Here's a question. Matt asks, in the LLC that we purchase operating names from your website, or should we sit down with someone like yourself and have it specifically written for your business? That depends, Matt. If you're asking people to become a member of your LLC, yes, you should have a lawyer draft something more specific. But if your LLC is doing business with someone else's LLC, let's say in a joint venture or lender-borrower situation, then my agreements are just fine for that. It's when you bring in multiple other partners, or maybe you would have me review their operating agreement that they're offering you an interest in. That could be a possibility as well. Okay, here's a good question. Oh, same one. Thanks, Matt. Great tips. Thank you, Matt. All right, put your questions in the Q&A there in the comments, and I'd be happy to answer them for you. Just put your question in the comments section there. Be happy to do that. In the meantime, I'm going to go forward here and tell you about a few more scams and how to avoid them, right? So, oh my goodness, that's going to be next week. I couldn't get to all 7. I'm sorry. So I didn't want to overload your brain with too much information on this. I decided, as a policy decision, I'm going to make these a little shorter and answer more questions rather than bombard you with too much information. So come back next week, same bat time, same bat channel. If you're watching replay, same YouTube channel, and learn about the last 3 most common real estate investing scams and how to avoid them. And make sure while you're here, you do subscribe to my channel, because you will get notified of new events announced and when new events start, or when I post new videos, which I do regularly. All right, so let's get some questions in over here, and then we will wrap up for the day and come back in a day or two, and you will see that, actually, if you come back later this afternoon, the stream will be available. Should be at the same link, I believe. At the very least, if you go to YouTube/Bronchick, my regular channel, you will see it there under Webinar Wednesdays listed. And make sure you stop by legalwiz.com/store and use the Wiz discount. Okay. All right, let's take some questions. And then we will go on. Janine asks, love that story. Would like to hear it again. Which story are you referring to, Janine? Maybe give me a little more information on that one. Keyfront Properties asks, what should we look out for when we're assigning to cash buyers? That's an excellent question. And one of the things that I really wanted to cover in this, but I didn't get a chance to, and I'm glad you brought it up, was you being the assignor and you're assigning to other investors. So asking for proof of funds, asking for how they're going to close. Do they have their own money, or are they partnering with someone? Who's their partner? You know, just the due diligence stuff. But the most important thing that I've seen lately happen is people who assign contracts to other investors. Then the other investor turns around and sues them for non-disclosure of some relevant problem with the property. Now, my general feeling is, look, be a big boy, put on your big boy pants or your big girl pants, do your own comps, do your own repair estimates, do your own due diligence, do your own research. Nonetheless, people feel the need in this, and I've happened to 6 of my clients who are investors. They assign the contract or double close to another investor on a wholesale, and that investor threatens to sue them for violating the contract by not disclosing this, not disclosing that, and keeping their earnest money when the person doesn't want to go through. And sometimes it's legit stuff, but mostly it's garbage. So make sure your assignment agreement, or if you're double closing, your contract has a really good as-is disclosure. As is, meaning you don't make any representations of any kind about the property, the condition, the repairs, what it's going to take, what it's going to sell for, how long it'll take to sell, blah, 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 blah. And I happen to have such a form, by the way, in my wholesaling course. If you haven't had a chance to get it, you can get it on sale with the discount code at legalwiz.com. If you have the course and you haven't looked in there in a while, look in the folder for the forms. There's an assignment agreement, and there's a separate as-is disclosure form when you're doing double closings that you put as an addendum to your standard contract. Okay? All right. Good question, by the way. That's a very, very appropriate question. All right, so make sure you stop by next week, next Wednesday, same time, to participate in part 2 of 7 most common real estate investing scams. This is Bill Bronchick thanking you for joining me today. And if you didn't catch everything, came in late, or I spoke too fast, probably, you can watch the replay shortly. Have a great day.